Mr. Callis?
Attorney, this is your attorney. If you say that this is my attorney, are you kidnapping me?
Yes, Your Honor, we're putting him in the room right now. That seemed to help.
All right, thank you. Good afternoon, Mr. Callis. The court will call your case 25 CR 29. I am District Court Judge Laura Maker up here in Aspen. I have your attorney, Mr. McCarty, with me here in Aspen, and I have the district attorney, Miss Adgate, with us as well. Your brother, Alex Callis, is with us as well, sir. Why don't I turn to your attorney, Mr. McCarty, first and hear from him. Mr. McCarty.
Thank you, Your Honor. First of all, Mr. Callis, it is a pleasure to meet you online. I am covering this case for the next month or two.
When do I have a right to be heard? I always want to know is when do I have a right?
Mr. Callis, Mr. Callis, can you hear me right now?
When I'm asking.
Can you hear me? Can you hear me?
When do I have a right to be heard in the courtroom? I'm asking the judge.
Okay,
Can you hear
Mr.
me?
Callis, I'll let you know that I'm going to hear from you today on anything you'd want me to say remotely. When you are talking to me later, after I hear from your attorney, Mr. McCarty, and from the district attorney, you can tell me that you'd like to appear in person. But I'll tell you, Mr. Callis.
This is your attorney. If you say that this is my attorney, are you kidnapping me? Is this kidnapping if you say that this is my attorney and I didn't hire this person? Are you kidnapping?
Mr. Callis, I'm going to mute you. I'll hear from Mr. McCarty, and then I'll hear from Miss Adgate, and then I'll hear from you, sir. Mr. McCarty.
All right. Thank you, Your Honor. Well, hopefully Mr. Callis got the impression that I am at least standing in on his case on his behalf from the Public Defender's Office for the time being. Your Honor, I want to just run through my understanding of this case as I see it. It looks like for almost a year ago, competency was raised in this case. There was not a competency evaluation actually completed or report submitted until it looks like the evaluation was completed in November of last year. And the report was filed on December 1st of last year, finding Mr. Callis incompetent to proceed in these criminal proceedings. Restoration classes, it appears to me, started sometime in February. And it looks like as of May, I don't quite understand what I'm seeing here, but it looks like as of May, there were reports that Mr. Callis was participating, was showing up for his sessions, at least 2 sessions in which some sort of issues prevented restoration services from being provided on those dates. I don't understand what that means. Maybe the court got to the bottom of that during previous hearings. But let's just say that it concerns me that when, as of May, Mr. Callis was attempting to participate in restoration services and somehow those services were not able to be provided, it strikes me as somewhat concerning that now suddenly that DHS is considering him not cooperative with his restoration services. So it appears to me that Mr. Callis was participating, that he was cooperating all along, and then recently, according to these reports, again, as with the previous case, I just see this sort of conclusory language being used by DHS to suggest that he just is not participating or that he has stopped engaging. And I don't know what that means. And I guess I'll make the record again because I know the court understands it, but we have a separate case here. But similar to the last case that we just discussed, I think it is perplexing for those of us in a courtroom addressing a criminal case to understand that a person who is not competent to proceed in a legal case is somehow expected to have some certain unexplained responsibilities to participate in restoration services. And so someone who has been found mentally ill to the extent that he is not competent to proceed in this case is somehow still expected to participate to the satisfaction of a person who is not here to explain to this court why he has somehow failed to meet his duties in the restoration services. It's concerning to me just because it is not clear why someone is not competent to proceed in one proceeding and then is considered to have certain responsibilities that he has not met in another, without any explanation as to how he has failed them. Now, it may be that he just doesn't show up, but we know that he's got a history of showing up. So I guess what I would suggest to the court, after a reevaluation in July, finding that his prognosis is likely poor in the absence of, quote, appropriate treatment, which appears from the context of that report to require psychiatric medications to be administered against his will, which of course I would also just add for the record that anytime a defendant in a criminal case is alleged to have committed a crime, their mental health or their mental state at the time of the alleged incident is important to defense counsel and ultimately to choosing a course of defense either through negotiation or at a trial. And whenever a person is against their will medicated, it changes who they are and it changes the ability of defense counsel to understand the person that they were at the time that the offense was alleged. So there are lots of problems with involuntary psychiatric medication that I see. Point being, I think this is an appropriate time for the court to, pursuant to 16.8.5.113 subsection 4B, to consider dismissing this case. It is certainly what I'm moving the court to do at this point after almost a year of proceedings, the complete apparent inability of DHS to restore Mr. Callis despite significant periods of time where he was participating or attempting to participate, and a prognosis that the state determined, or that DHS determines to be a prognosis that they've determined to be likely poor in the absence of involuntary medication. This is not a case that I would suggest to the court creates such, well, it actually is irrelevant to the court's consideration at this moment whether Mr. Callis presents some threat to the community. In the absence of the prosecution seeking some civil commitment or other types of approach. But I would also just say, I know the court is going to consider community safety anyway, and it does not appear to me that this case carries with it the types of allegations that would cause the court to have serious concerns for the community. I think Mr. Callis has participated as much as he can. He is now sitting in custody on several matters where his competency, I would argue, is the underlying issue probably in all of these cases. And I think it's appropriate at this point, since the state has failed in its responsibility to attempt to restore his competency, I think it's appropriate for the court to dismiss this case.
Right. I'll hear from Ms. Adgate. I'd also like to hear from Ms. Rippey. Ms. Adgate, do you have any preference if I hear from you or Ms. Rippey next?
Ms. Rippey makes
Okay.
sense. Thank you.
Ms. Rippey, what are you able to share with me today?
Your Honor, I would just say that Mr. Callis did actually attend many of his restoration sessions. I don't have an exact number. I actually requested that, but I haven't gotten it yet. There were also at least 3 that I know of instances that were not his fault. I would not consider them his fault that he
And
did
is
not
that
have
when it switched over from the library to?
Yes.
Yeah, okay.
Yes, I think there was a problem with trying to do it at Health Solutions West that were not entirely his issue. And then he's also, the reason that CDHS put in their letter was because of his incarceration.
Yeah, I saw
So
that.
he can't participate if he's incarcerated. But I do think he made numerous good faith efforts and did fully participate in his restoration sessions. The evaluator does not believe, based on the report that I read, that he would be able to be found competent without medication, although I'm not sure that based on his acuity, they would be able to enforce medication, but that's a question, I guess, for them. But I would certainly be willing to work with him to continue restoration if that's what the court decides to do out of custody.
Okay, thank you, Ms. Rippey. Ms. Adgate.
Well-
Thank you, Your Honor. As it relates just for procedural notes, Mr. Callis is not being held on this case today. He has not been held on this case. He's failed to appear many times in the past few months, but given the fact that he keeps meeting with restoration outpatient, and pleadings from defense counsel that they're working on things and that he's engaging and things are, and Mr. Alex Callis being present, we haven't issued any warrants or asked for any warrants to be issued on this case, given that he complies. People recognize that being in custody is not necessarily the goal that people have, or is not the goal that people have for people in Mr. Callis's situation. However, given the cases that keep coming up, and including the facts in this case where the charge is the attempt to disarm a law enforcement officer, the people have the community safety concerns that things are escalating. This isn't Mr. Callis's first obstructing or resisting case, or that the underlying facts are obstructing or resisting. And so the people still have concerns about community safety. And so that's why the people believe that the restoration process is still necessary at this time. That being said, this case has been set on the docket. The people reached out to defense counsel last week. If the people had asked time for defense to maybe file a motion in writing and time for people to respond to that motion. If that's where we're at right now, is that defense is making a motion to dismiss at this time, but the people would certainly ask for time to respond to that. Ultimately, the people are going to be object and ask the court to not grant that motion to dismiss. It is not a BRA case, just to make a side note. And then I did update Mr. McCarty prior to Mr. Callis's appearance today on the people's belief of why Mr. Callis is in custody, and ultimate way to resolve that issue at this time. I just want to make clear, yes, the people have not made any record, and I know Mr. McCarty made a record about Mr. Callis not complying with restoration, but that's not been the people's position so far at this time.
Okay. All right. We have Mr. Callis's brother, Alex Callis, with us today. Thank you for being here, sir. I appreciate it. I always appreciate when you come to Mr. Callis's settings before me. Is there any information you would like to share with me? You certainly don't need to, but there's the opportunity to do so.
Well, I know I did speak to the prosecutor in Glenwood, and I was at those cases too, and I know that they are not certain how to proceed. They were waiting on what was happening here, that they felt that more likely they would.
Okay.
The muni prosecutor.
Yeah, I understand.
And I know that, I know my brother has tried to participate, and obviously Health Solutions West posed a problem. He was trespassed from Glenwood Springs Library for a month, which would created that problem, and he's been trespassed from any of the health services in many other locations.
Which can't hear.
Okay. And just one second.
I don't think that.
And we were hearing from Mr. Callis's brother, Alex Callis. He wasn't speaking into a microphone, so the district attorney noted Mr. Callis probably couldn't hear what was being shared with the court. So if you're willing to reshare that, I would appreciate it. I'd like Mr. Callis to know what we're discussing here.
Okay, yeah, I was, I have appeared with my brother at most of his cases and just trying to be supportive and figure out what's going on, given his circumstances, and in municipal court in Glenwood Springs, where he has a lot of pending cases for being unhoused. I spoke to the prosecutor, who indicated that, he was considering not prosecuting those cases, as far as I know, based on what happens here today and what have you. And I did speak to, and then I haven't really gotten any information on Garfield County. I haven't had any conversations with my brother because I don't have access to him in Garfield County Jail. And anyway, I don't think him sitting in jail is best suited for him, because he has no access to services. And back to his restoration, I know that he had tried to comply with that many times. I went through extensive efforts to make sure he appeared for those by going to Glenwood, setting up, talking with Mrs. Rippey, and Mr. Bagsby at Health Solutions West, and then it got confused. Something happened there at the actual Health Solutions West where they kept wanting paperwork and that they wanted him to sign. And he, obviously the court knows that he has an issue with wanting to sign for things and requesting extensive documents. And so that posed a problem because he wanted to have time to read it, but he needs reading glasses typically to read things. So it wasn't going to happen right then and there for sure. And then when he has interactions with code enforcement or law enforcement, a lot of times his items go missing and he can't keep track of those items because he doesn't have them to know where he's supposed to be, so it gets very complicated. And, obviously, the situation is a problem for the people and for my brother George. And I'm just hoping we can find a resolution to hopefully find a way to get him some back on track.
Okay, thank you so much for sharing that with me. I really appreciate you being a constant support for your brother. Mr. Callis, I'm going to hear from you now. Sir, I'll let you know that I'm going to unmute you. You can share anything with me. I have limited time to hear from you, so I'm going to hear from you for about 2 minutes, sir, anything you would want me to know. And then I'll have to mute you and decide some things today. Mr. Callis, you continue to have the right to remain silent. I'm going to allow your attorney to provide you any advice that he might provide you, and then I'll unmute you. Mr. McCarty, anything you'd like to say to your client?
I think Mr. Callis probably knows he has a right to remain silent. I certainly urge him to invoke that today.
All right. Mr. Callis, is there anything you'd like to say to me today, sir?
Is the judge breaking the law to limit me to only 2 minutes for having a right to be heard?
This is your time to tell me anything you'd like to know, you'd want me to know, sir.
Well, if I only get 2 minutes and I leave here and they keep me here, is this kidnapping that the judge does or extortion?
Okay. And Mr. Callis, you're not being held on this case. You're being held on another case. Is there anything you'd want me to know with respect to this case, sir?
Has the sheriff explained in court about my property being returned? Has a gate explained in court about not providing to me from the prosecutors the copy of whatever information that they're providing to the attorneys that they chose to provide the information to? So I know what they have provided to them. And how long has this gone on? Has it gone on for months? Has it gone on for years? And when is it that a gate ever explained? Has a gate ever testified that she was hired by the prosecutors and she's not someone that's just showing up in court and showing her state of Colorado driver's license and state of Colorado ID? Has the prosecutor ever showed up in court to testify that he hired a gate, and either of them gone over their own election results and whether they were reliable or not? And if they're going to provide this within whatever amount of time they need to provide it, as far as knowing who your accuser is. Has the neighbor to a gate and the sheriff, the municipal police on the state of Colorado highway provided property to me? Or have they provided any explanations in court about having my property returned to me? Have any of them, including whoever is the chief of police, testified in court that they hired these other people, that they were hired as police or chief of police and hired other people who are police?
Okay.
Yeah.
And Mr. Callis, I'm just going to interrupt you because the case before me, sir, doesn't involve the municipal police. You've got about 30 seconds. If there's anything else you would want me to hear or consider today, sir, is there anything else you wanted to tell me?
When have I ever had provided to me with the accusations that you've gone, that have not been gone over, but have been hinted at? When have I had this provided, the details of it? either orally in court, or that that person provided the testimony in court, or provided it to me in court, or just even in writing from the court. When have they ever provided the people in the courthouse building provided testimony that they've refused me services of the courthouse building, or that the courthouse property, that they have not returned my property from it?
Okay. All right. Thank you for sharing that with me, Mr. Callis. I'll let you know a couple things. You appeared before me on August 4th, 2025. I did advise you at that point in time of the charges in this particular case. I also physically handed you a copy of what's called the information, the charges in this case. It sounds like you may have misplaced or lost that. I'll tell you that we're perhaps quite a ways away from really substantively addressing those charges that are before me. And that's because I have found you incompetent to proceed. We've discussed that before. I have ordered you to comply with restoration services with the Department of Human Services. There was a number of times that you met with the Department of Human Services there at the Glenwood Springs Library because you'd found it difficult to come back up to Aspen. At some point in time, you were no longer able to be at the Glenwood Springs Library, and so those services had moved over to Health Solutions West. I've received a report that indicates that perhaps you have not been able to make forward progress on the restoration services. Your attorney here today has asked that I dismiss your case because you won't be able to be made competent and you won't be able to really assist him at a trial. The district attorney has indicated that she would like the opportunity to require a written motion be filed so that she could respond to that. That's really where the court is at today. There's been an oral motion. The court is inclined to require a written motion so we have a clear record and the court can make a determination on that. So what we'll do next is the court will reset this matter. I am going to order inpatient restoration services at this point in time. So the court will enter a JDF 39 for inpatient restoration, given that Mr. Callis is currently being held in custody. Although, as I said, Mr. Callis is not being held on this case. The court is going to certainly not foreclose any filings by his attorney, Mr. McCarty. I think perhaps we have a sense of a filing that's coming. The court would allow the district attorney to respond to that filing. Mr. McCarty, how much time do you think you'd need for that filing, just so that I have a sense of when it makes sense to reset this matter?
Well, Your Honor, I've made the motion. I certainly
know.
am not conceding that the motion doesn't exist unless it's in writing.
Yeah, I
I'm
understand.
happy to accommodate the court's preference, but in terms of timing, can we work backward? When would the court like to reset this?
Yeah, my thought is to set it on the August 31st, but I'm willing to hear from both parties.
No, I could, well, I could speak for Mr. Gate on a response, but I would probably require a deadline of August 14th to get that filed.
Okay. And I'll just let you know, I'm not going to set a deadline. I think you have the ability to file that at any point in time. It's helpful to me if you file it by the 14th because it just allows us to move along. Ms. Adgate, if that's filed on the 14th, how much time do you think you'd need?
Could have a week from that time.
Okay, that seems realistic to me. All right. So we'll go ahead and say that any motion to dismiss that's filed, the people will have a week to respond to it. And we'll set the next appearance in this matter on August 31st. Deputy Blatter, are you able to accommodate a 1:30 setting? I know we'd set it at 2:30 today, so perhaps there are things I should know that I don't know.
Yes, Your Honor, we have our advisement docket at 1:30 and it oftentimes is pretty heavy. So that's why we usually ask for 2:30 setting.
Okay, so we'll go ahead and set this on August 31st at 2:30 then. The people to writ. I'm seeing heads shaking, but perhaps a stand up. Is there anything else I should be considering?
I just would note, I might file something. I think I've done it in a few of the cases. I anticipate Mr. Callis will be out of, depending on what happens on Thursday, if he signs, he's being held after today, I think he'll be held on a PR bond that he won't sign in the Glenwood case. And I've brought that to Mr. McCarty's attention. So he's set to appear in front of Judge Roth on Thursday. And so ideally, I think he'll get out by Friday. So the people will just take note. I'm just bringing that to Ms. Ribby's attention as well, that I recognize this as inpatient or in custody restoration, but we'll deal with that by the next court date.
Yeah.
But I'll file the writ too.
Okay. All right. Well, Mr. Callis, I will next see you on August 31st at 2:30, sir. If you're in custody, there will be a video writ that will allow you to appear as you've done today. If you're out of custody, you need to make sure that either you call in or you come in person, sir. I welcome seeing you in either fashion. All right, that's everything on Mr. Callis's case. We'll go ahead and go off the record on that. Have a good rest of your day, Mr. Callis.